welcome everybody here again. So I'm really pleased that you can be here this evening. As I shared, I'm Beverly Porter, and I had no idea 20 years ago when I started connecting with some of the ARC services that I would end up being guardian of my family member, and I would end up with some of the responsibilities and challenges and advocacy roles that I have now. It's helped me a great deal to hear other families talk about their challenges and their decision making. And so tonight is an opportunity for us to talk about what is the dream? What is the dream for our family member with a developmental disability, and how are we going to get there? Also, the things we don't always want to think about, like what is the nightmare? What are the scary and concerning things that we want to do all we can to avoid problems and difficulties? And what supports are available within our community, within technology and processes, even legal and financial processes that can really help and support people with developmental disabilities to make decisions. And you might ask, why should we plan for decision making in the future? One of the things that has changed with the guardianship law and a great deal across the world is a recognition that everybody has the ability to make decisions, but that can change over our lifetimes as we grow and learn. And people with intellectual and developmental disabilities do have the capacity to be involved in their decision making. There is a United Nations Charter on the rights of persons with disabilities, and it includes statements that people with intellectual and developmental disabilities, as well as other people with disabilities, have the same rights to make decisions about their lives as people without disabilities. So I wanted to highlight that tonight and recognize and try to respect what that right may look like for my family members and for yours. Most of us are making day-to-day decisions, and our family members are deciding what they want to wear, what they want to eat, where they want to go, who they want to talk with, or who they don't want to talk with or spend time with. And this takes practice. Young people can learn and practicing to make better decisions as they grow up. So practicing decision making can be very helpful, and having the dignity to make mistakes. We all make small and big mistakes, and learning from the bad and the good, the consequences of their choices, helps us to feel more successful and confident in making decisions, even with support. So you may have already done some work in your life and in your family member's life to put some pieces in place that are legally and financially supporting them in decision making. And that could look like representative payee for supplemental security income and Social Security. It could mean power of attorney with finances or healthcare. Person-centered planning is a process that can be done to help define and identify needs and decisions and help somebody make progress towards those of whatever decisions they want to make in their life. There are a variety of decision-making supports, and ones that I like to think about as accommodations. My family member may really need more time to process information and quiet to do that. So say if we're at the doctor's office, I want to make sure that the accommodation for them to make a decision means that we give them the space and the time and the calm to be able to make a decision that's going to work for them. And guardianship and conservatorship are listed here. Those can be full or limited, depending on the courts. So supported decision making, as I said earlier, I think about that as how do I offer and provide accommodations? So just as people without disabilities need support in making decisions, sometimes our family members, or maybe always our family members, need support to make decisions. Explaining options talking about what the negative or the positive consequences are. Even this is something that even happens, say, at the dentist, in terms of talking about if we want to fill this cavity or let it go and not take care of that cavity right now. If somebody declines to have a cavity filled, what are the consequences of that? So these are daily and regular decisions that may not seem like they're too overwhelming for you, in ways that you can help to build that decision-making process for your family member and strengthen your relationship. Family member may need help understanding that information that's been provided to them, medical information, dental information, information from a DDA case manager, or information from their employer. And they also may need supports in terms of communicating what they want to people who may not understand them, and maybe being able to translate or interpret what you understand that person's preferences and concerns may be. Once people do receive that support, many people with intellectual and developmental disabilities can make their own decisions. We do know that, unfortunately, unexpected things can happen at any time, and those things can really impact our ability to make decisions. And for any person, if plans aren't in place, that can limit our options later on. So taking some steps before a crisis and to anticipate possibilities, it can really ensure that your family members' choices and needs are going to be respected. So in terms of talking about all of that, that's an opportunity for you to talk with your family member about what kind of decisions would they like help with? What kind of help do they want? Do they want someone to explain things further? Who do they want to help them with that decision making? These are all ways to really empower them in daily and in larger decisions. Encouraging them around those small day-to-day decisions about what they want to wear, what they want to eat, what they want to do or not do, and thinking about, again, the consequences of choices that somebody makes or decisions they make to maybe not do something as well. It also can be really helpful to talk about the steps that somebody has made to make a decision. And you may be able to pull ideas out of your life in thinking about how maybe your parents or siblings have involved you in medical decisions, or looking at what may happen in terms of like addressing a special needs trust or somebody making a will. You being able to talk about how that decision making has worked for you, and the fact that families can work together, hopefully, can help to build their confidence in their ability to do that as well, and gain information, vicarious information about that experience. And one other way that folks are really helping to become more independent and have some abilities in making decisions are a lot of things through assistive technology that are assisting folks in getting information and being able to communicate information back around particular decisions. If any of you are connected through DVR, the Department of Vocational Rehabilitation, there are some amazing applications and things that may be on a smartphone or on an iPad that help people to manage their day and their time and their decision making throughout their day. So some really good ideas that can build, as I said, some independence and help your family member to feel that they are able to make their own decisions and control their lives, and hopefully feel less frustrated that they have so much more control over their activities. So there has been a burst of information and encouragement towards supported decision making, and because of that, there are more and more ways to look at how people can be supported in terms of their decision making, along with some ideas about like my plan, or there's a resource here called A Letter for My Doctors that is a really good example of a supported decision-making agreement. And in fact, there are some resources that we will share as we move through the evening and at the end of the presentation as well. But there's some legal forms that will help show a court, a doctor, a bank, whoever, that your family member has the capacity to make these decisions, has the capacity to be supported and given accommodations in defining how their life and what goals they're working towards. And oh, I have to stop sharing and reset my screen here. My apologies. That is going to take me just a second. I wanted to show you a document that is just got away from me. There we go. Nope, that's not it. Well, that was not my plan this evening. Let me see what I can do here. There we go. Okay, I have to scroll down. There we go. Maybe I should have said this. Where do I want support? Because that is the next page we're going to. What kind of support works for us? So this document here is something that I can email to folks, or we can print out and share it with you. However, this is a really nice, friendly way to talk about with your family member ways that they would like support with a particular different, kinds of decision making. And I like this because it has a little bit of graphics and really helps folks to be able to say, hey, I can already do this alone. I have the ability to tell people what I want and don't want, and I don't necessarily need support with that. Maybe I can make decisions and tell people about those choices when I'm given an accommodation, to have further time, to have some quiet while I relate my needs and my preferences and my choices. So this form may be really helpful for you to look at some different things about what does it mean to stay safe? What are the ways that I have of making sure that I'm safe, or get help if I know that something is not working well in my life? My child, when we first started the guardianship process, asked the attorney, what do I do if my guardian's breaking the law? So that kind of decision making, even though I'm a guardian and I can provide that support for them, they still have the ability with supports to talk about, how do I get help? What are the avenues that I can take to get other support? Home and friends, being able to choose where you live, who you're living with, how you're spending your time with other people, looking at medical care, about dentist and doctor visits. And for some of us, and this might feel more uncomfortable, is thinking about dating, your choices about marriage and your wishes as you get older, and even thinking about sexuality, about pregnancy. Does somebody want to travel? Would they like to be able to go to Disneyland or fly into Florida and swim with the dolphins? So these are ways that we can look at person-centered planning, or defining a little bit more on this about what are other ways that I can be supported in my life. Money, again, the finances in terms of paying the rent, keeping bills, preparing a budget, and making sure that nobody is taking my money or using it for themselves, that my money is supporting me in my home, in my shelter, in being safe and healthy. And as well, things like signing contracts, business agreements, that can be about a cell phone or a rental agreement. So it can be small and large things. And choosing who to vote for and voting. So these are all rights that folks have when you turn 18. These are all rights that anybody has. And ways that we can be supporting somebody in knowing their choices and developing those. So kind of a next step from supported decision-making is substitute decision-making. And that's making a decision for somebody because they can't make it for themselves. And that can be some examples of that here are representative payee and power of attorney for healthcare. And these may be something like, say, with financial affairs, that somebody's ability to get information and kind of evaluate that and think about their money, to understand their budgeting, that if they spend X amount of dollars on video games, they're not going to have enough left to buy groceries. These are areas where a representative payee is having some support and control for a person to ensure that those dollars that come from supplemental security income are going to food and shelter. And we had this interesting little story I'll tell you. One day, the mail came and it had the April bank statement in it. And my family member that I'm representative payee for opened the mail, opened their bank statement, and yelled out that nobody had told them. And they were angry and they just stomped around for about 5 minutes, occasionally yelling, "Nobody told me." And I didn't know what the issue was. I did not know what the bank statement said, but I knew it was their bank account. It was their dollars from Social Security, and they were angry and frustrated. And then they told me, they said, nobody told me that I didn't get my Social Security in April. This is the moment that I learned how to be a representative payee. And I said, grab the binder. We've got this guardianship binder. And so I pointed it out in the living room so they know where it is. And they pulled it out and I said, open that first section that says banking. And they did. And there was the March bank statement. And we looked at that together and I pointed out that on March 31st, the Department of Treasury had made a deposit for their SSI. And so their April Social Security had been deposited at the end of March. So yes, we didn't tell them they didn't get their Social Security because they got it. They just got it on the wrong day. And that was the moment that I loved thinking about, how else do I teach this person, this amazing person in my life, to expect respect, to be able to ask about their finances, even if they don't fully understand it, to know that people can be honest with them and should be. So that was kind of this aha moment of being able to say, oh, this is really an important job. And if I do this right now, at some point, somebody else is going to be the representative payee. And hopefully then my family member knows what to expect from them in terms of respect and access to information and honesty. So substitute decision-making can also be done in terms of using power of attorney. And this is another legal process to go through, but it's not as extensive as guardianship or even some of the information about Social Security. So power of attorney it can be very broad or it can be incredibly limited and just focused on one topic, such as disability services or finances. And you can use power of attorney for healthcare as well. So we did add this information here, and it will be at the end of the presentation as well. There are specific forms for Washington State that meet the Washington State law around power of attorney. And those forms are available online for free at a website called Washington Law Help. So there are two forms. One is for power of attorney over finances, and the other is for power of attorney over healthcare. So those are, and with those forms, I do want folks to know, you can download those or we could print those out for you here. You would need to take those and fill them out and then sign them in front of a notary. So that's the only requirement, is that they be signed in front of a notary. And your family member, of course, would need to sign those forms in order to assign you as power of attorney for their affairs. And then that leads us to certainly the most restrictive option of some of this financial planning, which is guardianship and conservatorship. This was changed in Washington state law at the beginning of 2021. And so it used to be that you were you had guardianship of the person and of the estate, and conservator or conservatorship is the terminology that's used now to refer to the financial and the money aspect of supporting somebody. This other piece here in terms of thinking about competency or capacity is around whether or not somebody can make decisions about if that person has good judgment. And there are ways that this can feel really negative, certainly. And I know that when I saw the physician's report that was sent to the court regarding my family member's competency, I didn't think it sounded very nice at all. But I also understood that it meant that my family member was not capable of adequately caring for their health and welfare and managing their finances, and was at risk for that reason, which is why I was appointed as guardian. So there are some myths about guardianship, and I wanted to run through just a couple of these. Don't most people with intellectual and developmental disabilities, with IDD, don't they need a guardian? It's not necessarily true. To become a guardian, you have to go to court, and a judge will decide whether or not that person can make their own decisions or if they need a guardian. And the judge will also decide who the guardian will be and what decisions the guardian will be able to make. So are parents automatically guardian of their adult child with disability? No, that is not how the law works in Washington state or in the US. All guardianships require going to court and getting a court order, no matter what a person's disability is or how that disability does impact them. Myth number 2 is about individuals who've been appointed guardians. If you are appointed guardian of a minor child with a disability, would you remain their guardian when that child turns 18? And that is not true. Guardianship over children and adults both require going to court and getting a court order from a judge. They are different processes with some different requirements, but guardian over a minor child will end when that child becomes an adult. Do parents need guardianship? Once your child becomes an adult, do you need guardianship in order to access school records, medical records, legal records, other things like that? Not necessarily. An adult with a developmental or intellectual disability can sign a release of information or some other authorization forms that allow a parent to access some or all of any educational, medical, and other records. There is a form that most school districts have that a student can request or a parent can request so that you can still have access. And most medical providers will have a release of information, a form that you can sign that allows other individuals to, that I think could include you as parents or other support people, to talk with a medical provider, to arrange appointments, to manage prescriptions and therapies, and to access some or all of their medical records. Oh, and it was on that screen already. Myth number 4, parents need a guardianship once their child becomes an adult to attend IEP meetings or other meetings related to their adult child services. And that is not true. Parents' rights under the IDEA, the Individuals with Disability Education Act, those rights transfer to students when the student becomes an adult. But here's the great part. Parents must still receive all the same notices that the student is now required to receive. And so you will still receive an invitation to school meetings. You'll receive a information written notice anytime that the school wants to change or is refusing to change services, educational services, or special education services. So all of those notices are going to ensure that you know about meetings and that you can attend the meetings if you have your child's permission. Parents can also know about any changes that are coming up, so you can have a conversation with your family member, discuss concerns, strategize together, or even take steps to disagree with the school. You don't need guardianship to attend a medical appointment or other meetings. All you need is permission from your adult child. So that means having some conversations about how do we make decisions together? What does support look like you? How can I help you with those concerns? And myth number 5 is about how protective guardianship may or may not be. I know that I hope the guardianship will protect my family member from financial, from physical abuse, from any sort of exploitation. But I also know that that doesn't stop them from getting into trouble, from maybe giving away some money. Even though they have access to very little, they could still give away the money that they do have access to. They could be injured or somehow be taken advantage of. So guardianship does allow you as a guardian to be an advocate, to have that legal authority to take action on behalf of your family member after a financial or some other abuse or exploitation may have happened. And folks can be assigned and support a person. Say your family member does want to pursue some of their own legal action. So you can support them in that as well. So in that way, guardianship gives you room as an advocate to support. So the best way to hopefully prevent people from intellectual and developmental disabilities from being exploited in any way or taken advantage of is that education piece, how you're talking and communicating and sharing information about how they should be respected, about safe choices, about healthy relationships, and recognition of uncomfortable or awkward or even bad situations. So if you still want to be a guardian, there are some responsibilities in that advocacy role. Representative payee requires that you do report on those finances to the Social Security Administration. And as guardian and or conservator, you do have to make reports to Whatcom Superior Court on a regular basis around the finances and the living situation of the person. And I don't want to overwhelm you, but I did want to show you a little bit about if this is your job, the court wants to make sure that you as a guardian are making sure that that person's status is healthy and safe, that they're receiving all the services that they should receive, including educational ones. If they still have an IEP and they're involved in community transitions until the age of 21, what kind of services are they receiving? What are their living arrangements and their medical condition? So there is this responsibility that the guardian has to ensure that services and supports are available to the person. You don't have to necessarily provide all of those, but you need to make sure that those are in place. The court asks you to report on your activities for the benefit of the individual. And it's helpful to know this if you think that, you know, at some point somebody else may be my family member's guardian. There is a requirement that the judge will find out how often the guardian visited the individual. What dates did they see them? What kind of extent, what extent does the individual participate in decision-making? I know when I turned this form in recently, this report to the court, I described that my family member decides when they sleep and when they want to wake up, what they're wearing, what they eat for meals, what their menus and meals look like. So there's a lot of daily decision-making around their health and welfare that they are taking advantage of and very appropriately. So I wanted the court to be able to know that. Let's say in 5 years or 50 years, somebody else is being their guardian. The judge knows, the court has information that my family member's been able to make those decisions. And hopefully then, whoever that next guardian is letting them take full advantage of that, is allowing and supporting my family member to feel like they are in control of their lives as much as they can be and feel supported in that. So there are other pieces of information here that the court requires of anybody who is being guardian and conservator. And as again, I didn't want folks to feel overwhelmed or threatened by this, but we do need to report on the finances. And I'll just give a little tidbit of relief to you here. This is the report that's used for anybody. So let's say I'm Bill Gates and I've just had a stroke and I have dementia and you want to have guardianship of me. My real estate, my bonds, my investments, all those things would need to be listed here. So guardianship can be done for anybody with some sort of disabling condition that may impact their ability to take care of their health and welfare. For our family members, they usually don't own property or have many of these other financial assets. So I want to assure you that the paperwork looks extensive and it's not as, there's a lot that you're not going to have to fill in because your family member doesn't have mortgages or bank loans or anything like that. This is the biggest thing, that the day you are assigned as representative payee and or guardian and conservator, you will need to account for any income that your family member receives, either from Social Security, SSDI, or through SSI, the Supplemental Security Income. They may have wages from work. And so this report would cover 1 year or even 3 years of a guardianship. So when I did my recent reporting, I looked back over statements and recorded what 3 years worth of supplemental security income was as the only income that my family member had because they are not working. And then I have kept track of every penny of that Social Security and what it has gone towards. So room and board, that would include meals, utilities, internet, all that good stuff. Keeping track of personal funds, any medical or dental costs, and if there's travel and entertainment, information on that as well. So this is what you as a guardian and conservator would need to report back to the court. I like to share this with all of you before you become a guardian, so you can actually start keeping track and you don't have to dig through bank statements or other things later to try to determine what those costs were. And so that's pretty much, oh, and then the court asked too, are there other ways to be able to support this person and help them in making decisions that are not as restrictive or as controlling? And please tell us about that. So the court's going to continue every time that you report in to find out a little bit of the status of the person, what their needs are, and that sort of thing. And then they want you to make a guess about what a budget might look like for the next while. And so there's some information that they ask you to guess on. And I want to reassure you on this one as well. It's an estimate. You are not going to be followed up by somebody who said, oh, well, you said $745 here and it was $750. This is just what you're doing currently and what you're proposing to do. And again, say this were Bill Gates, someone may propose to spend additional money on travel or some other things because that money may be available. And in your family member circumstances, as mine, it's probably not all, there aren't all those those pieces available. So I want to stop sharing.
We had a quick.
Okay, I saw some questions here. So how often is the guardian required to report to the court? That can vary. It's either 1, 2, or 3 years. I think with most folks with developmental disabilities, when you're appointed generally when your family member is 18, it's usually 3 years because the court recognizes that there aren't a great deal of assets that the person has, and there may not be as much information to provide as opposed to, say, someone who's recently had a stroke or has dementia and has a lot more assets in their account. So the court may want to keep a closer eye on that for that reason. So it's usually every 3 years. And yeah, I think it's overwhelming to see so many pages. And I just want to reassure folks that it's filling in the blanks. So some of it is not too tricky. Another question that came up is, are the Guardian Court Finance tracking sheets for individuals only? Is a special needs trust a separate entity that's not reported here? So that's a good question. I haven't messed with that. Yes, the ARC can help out with filling out those forms. And I'm gonna stop the recording